1.
Good afternoon, and welcome to this interactive training workshop that is being conducted virtually with the HART board. As I call the meeting to order, please join me in please everybody mute your devices, first of all, unless you're speaking, and then join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And Ms. Arthur, if you would, take attendance.
Absolutely. Thank you, Chair. Director Castor?
Here.
Director Hudson? Director Johnson?
Here.
Director Kemp? Director Knight? Director McLean? Director Myers?
Here.
Director Overman?
Here.
Director Schisler?
Here.
Chair Smith?
Here.
Director Frazier? Director Frazier?
I'm here. Can you hear me?
Yes, thank you. Director Vieira? Director Williams?
Here.
That concludes attendance. Thank you, Chair.
Thank you. And as a reminder for everyone, in accordance with the HART Board Policy 220.01, a workshop is a gathering where board members or a person or persons designated by the board may be present at the meeting for any legal purpose, but at which time no official votes are to be taken or policy adopted, and at which public comment may or may not be recorded. Do we have anyone who does wish to address the board at public comment today?
No, Madam Chair, there's no one pre-registered to speak.
Okay, so that takes us to the interactive training workshop, and we'll start with our General Counsel, Julia Mandel, to provide a training on government in the Sunshine Law.
Good afternoon, everybody. I do have a PowerPoint that will also be brought up, and this is the first time I've ever done this virtual PowerPoint, so if I mess it up, I'm sorry. But this is actually a presentation I have been giving to different agencies over the last couple of years. I have been involved in public records and sunshine law issues for 25 years. And so I've probably either seen it all, heard it all, or been involved in it all, and then tried to fix it as I could. Fortunately, nobody I'm aware of has ever had the penalty phase of this presentation involved on them, so I feel at least that is something I'm relatively proud of. But in any event, for some of y'all, especially those who are elected members of our board and ones that have been in government for a long time, you've probably heard this similar presentations before. That being said, it's always good to refresh because we get in our day-to-day lives and we forget that, oh yes, we are doing this work for a governmental entity, and we do have to remember and recognize what that means. So we'll go ahead and get started. And also, I'd like any questions, please stop me, because I feel this is a better presentation if it's interactive, and if specific questions or issues come up, it's better just to go ahead and stop and have that conversation. It is Friday afternoon, and I know we're not all trying to be here as late as possible. That being said, I think there's value in stopping and having conversations about specific points. So,
just for the record, sorry, this is Commissioner Pat Kemp. I just wanted to say I'm present.
Good afternoon, Commissioner Kemp. All righty, so we'll go ahead and get started. We'll go to the first slide. Okay, very good. Well, this is a presentation on government in the sunshine, and we all hear that. What does that mean? It refers to the constitutional and statutory provisions enacted to provide for transparency in government operations and decision-making. It's two parts. We say government is sunshine, but what's really two parts? One is the public records law, and the other is the sunshine or open meetings law. We'll talk about those separately. There are some overlaps, but I think for the most part, for everybody's purposes, the public records law is the one that is the most confusing and confounding, although what we have learned during COVID is the sunshine law and open meetings law has its own complications. Next slide. The most important thing for public records, as we talked that through, is what is a public record. And Florida statutes defines what a public record is. Any material made or received by an agency or employee in connection with official business, regardless of its physical form. This includes emails, text messages, documents, papers, letters, maps, books, tapes. We don't have so many of those anymore. Photos, films, anything that you have, which is a document that you do in the course of your official business in the either working for or representing a public entity is a public record. And it doesn't matter if it's a draft that you send around or it is the actual document, it is a public record. That's really important because what is a public record informs how we respond to those requests for public records. It's a very broad statutory requirement. It doesn't matter how it was created or conveyed or how it goes through an electronic transmission. Now, sometimes there might be exempt or confidential material. That does not mean it's not a public record. It just means there's parts of it or the entirety of it that's either exempt or confidential. What public records don't include are personal notes to yourself and anything you do on your personal email that is not, or your phone, which is not related to your official business. So my point is if it's to yourself and you jot down notes in the middle of a meeting, you're, kind of talking to yourself through written form, even if it's a text message to yourself, which I actually do to remind myself of things, it doesn't make a difference. If it's only for you to be the intended recipient of it as the writer, it is not a public record. If it is something you're going to send out or you do send out to somebody else, it becomes a public record, even if that doesn't go to somebody who is in the agency. Now, your personal phones and we'll talk about this more in detail because you do get a lot of confusion about using personal phones versus business phones, personal computers versus business computers. If it is something that you use that is personal, not for business at all, it isn't a public record simply because you are a person in a public position. Next slide. Now, certain documents that were drafted as public records have either exemption.
Excuse me, Julia, this is Adelie, I'm sorry. Can you just repeat the last, take a note, can you repeat the last thing you said on the previous slide about if it is personal, the very last thing you said, if it's your personal device, yes, if you could just repeat that one more time.
You're doing something on your personal, just because you're a governmental, in a governmental entity, or you are doing, have a governmental position, you have the right to use your personal email accounts or your personal cell phones for personal business. If it's a strictly personal action that you're doing, then it is not a public record. It has to be something that is written or otherwise delineated, which is part of your official duty. So, and I'm going to go through this more. I have some examples that will kind of make that more clear to you as we're moving forward.
Thank you.
You're welcome. And like I said, please interrupt me because it's important to understand some of these things because it can get confusing. Okay, next slide. Plus, I'm talking a little bit fast because I know we don't want to be here all day, all evening on a Friday evening. But if you need me to slow down, I sure will. Or if there's certain items that you want me to talk more about, I sure will. The next slide relates to exempt and confidential records. Again, just because there's an exemption or something's confidential doesn't mean it's not a public record. It simply means it is not either obligated to be shared through a public records request or is exempt from being shared, meaning you don't have to share it. Confidential is a document that cannot be shared. Exempt is something you can share, but you're not required to. But it's still a public record. There are a number of exemptions that are delineated in Florida statutes. It is important that if you believe there's exemptions or confidential information within the body of the public record, that legal counsel reviews it for that determination, whether it's board counsel or in-house counsel. It needs to just be reviewed to ensure that if there is something that shouldn't be disclosed or can't be disclosed, that it's not. So that's something that should be reviewed by legal counsel. Some of the things that we look at as whether or not it's either exempt or confidential, security-related plans and procedures are confidential. Blueprints and diagrams depicting your HART buildings are confidential. Social security numbers and medical records are confidential. Addresses of HART employees, some may be, some may not be, depending on the employee, but those are also confidential. Attorney work products, while litigation is ongoing, can be deemed exempt and also confidential. It just depends on what the document is. But the bottom line is, if there's a question, please discuss that with legal counsel. Next slide. The Florida Public Records Law applies to any and all communication to or from citizens, government officials, or others that involve public business. What this is, and I read that out so that it's very clear. It has to relate to public business. This applies to the content of the message, not the form, and we'll talk a lot about the form of different messages because this has changed over time. All of the rules apply to emails. When I first started doing this, we worried a little bit about emails. Now you worry about emails, text messages, which are the downfall of everybody and their fears as it relates to public records, instant messages, the kind you do on like Facebook or whatever other ways you do it, YouTube, videos, Facebook posts, comments, pages, Twitter, Instagram, etc. All of those are developing technology, and it really has no part to play in the determination of whether or not something's a public record, whether it's an email, a text message, or something which is commented on Facebook. If it is done in the course of official business or involving your role in the public business, it is a public record. The whole point is it doesn't matter the platform. If it concerns public business, it's a public record and subject to disclosure. Next slide. Kind of going back to what we were talking about, the difference between public business and personal business. And we'll use it in the context of text messages. And I'm going to emphasize text messages because that has become such the much more significant form of communication. It's quick, it's easy, it gets there, you can find out very quickly if there's been a response to it. But a text message is a public record if it is a message which is intended to be related to public business. So, for example, let's meet at 5, let's grab lunch is not a public record, even if it's two public persons, because they're simply talking about them having lunch, which is not public business. Be back in 10 minutes, same thing. No, that is not public business. Something that is public business. Turn on the projectors in the conference room at 9 a.m. If that is part of your job and it's being done to further public business, you have to keep that text message. And we're going to talk a little bit about archiving later. Let's go over the terms of the contract. Another one, keep. That is obviously relating to public business. Next slide. We'll go into further text messages, whether this is with board members, with vendors, or whatever, whoever you're speaking to. Check out this fish I caught on vacation. No. How is your husband feeling after surgery? No. We'll see you at the HART event tonight. Yes. Let's go over the terms of the contract at lunch. Yes. And this would be text messages as it's delineated there, not between board members, with a board member and another member of staff. We'll talk more about messages between board members when we get into the Sunshine Law. Text messages, next slide please. Text messages with other parties. Very similar, but these are the types of text messages you would be keeping if you were having a conversation with somebody who was not within your organization. City, county contact person regarding public business, you keep. Friend, even if it's just a general friend that you're discussing the proposed legislation that you are advocating on the part of your entity, keep that. A licensee or a vendor, any business that's being done, you just keep anything that relates to public business. And I think that's an important point because when in doubt, keep it. If it turns out it's not a public record and it's exempt from public disclosure, let the lawyers help you figure that out. Next slide. And this slide and this really relates to that mix, which is, again, especially with text messages, it's really easy to merge personal business and public business. If a text message you receive or you send contains both personal business content and personal information, the personal portion may be redacted prior to disclosure. For example, "Hi Bob, hope all is well with you and the fam. Is your son still playing ball? Would you like to schedule some time to go over our new contract and scope? Let me know when you have a chance to talk." If there was a public records request, we would have the right to redact a portion of the message which relates to the personal discussion of how the family is doing and is your son still playing ball. That doesn't mean the message cannot be turned over. It means we have the right to redact the personal part of the information. Next slide. This is a discussion of devices where you keep a text message, but it's the same for any other devices. It's just phones are the ones that we carry with us, and some of us tend to have 2 or 3. So, but the whole point is regardless if it's a personal device or an agency device, you have to be cognizant that it needs to be, that public business messages must be kept. If you have an agency-issued phone, typically it's a lot easier, and you shouldn't, and you could only be using your agency phone. And I understand we don't do agency phones very often at HART, but I point this out just generally. If it's an agency-issued phone, you should not be deleting anything off of it because you should only be using that phone for public business, and there's an assumption that everything on that phone would therefore be a public record. Again, if there's an exemption or something else, that's fine. That can be managed, but it is an agency phone, and nothing should be deleted off of that phone. If it's a private phone, if it's paid for by the agency, and it really doesn't matter even if it's paid for or not paid for by the agency, you have the same requirements. Except that with your private phone that's paid for by the agency, I would recommend that you keep everything and don't delete anything because it is something that may have more limitations on your use for non-agency business. But regardless if it's a private phone and you're using it for both public and private business, you can delete messages that are not private, that are private, but you have to be very, very careful to archive that which is public. And the archiving part of it is probably one of the more complicated questions because it depends on what your ability to archive is. So let's go to the next slide, please. So this is a discussion of storing and really archiving your email messages and text messages. Email messages, especially if you have a HART account, that is much easier to archive because they should be automatically placed into the email system. So those messages should be able to be archived, able to stay in in the system, and if there's a public records request, much more easily available for review. Now, if it's not a HART computer, or alternatively, you're using a private computer and a private personal email address, what you're going to want to do is make sure that any emails that you have, and this does become the responsibility of the person who has either the email or the text message, for you to archive those by emailing those to, and what they're asking you to do is email with the subject of HART business identified in the subject line and send that to HART so they can go ahead and archive that. So what I would do is if you're using a private email address or a private computer and you're ending up using it for public business, I would just forward all of those emails to HART. That way you know that they're archived, and that way you're not personally responsible for continuing to archive those. Because if you don't archive them and there's a public records request and you haven't followed that procedure and you haven't made sure that they've been kept in a server that can be searched, you could be in violation of the public records law, even if it's inadvertent. But it's very important that you understand that. And again, with email messages, it is just easier. People have a tendency to treat those as documents in that regard, like a filing system. Then there's a lot easier ways to archive them. Text messages are really the trickiest part. Not every phone has the same archiving feature, whether or not you have an iPhone, whether or not you have an Android phone. How are those stored, whether it's Verizon or AT&T, for how long they're stored for. So the best thing to do if you are receiving business-related text messages to your private phone. Now, if they're on your public phone, there may be automatic archiving systems within your phone. Notwithstanding that, it is important that you save all of your public business text messages. And the suggestion is that you forward those via email. I screenshot them. What I do is I actually take the time, screenshot my public emails that are to my private phone. I screenshot them. You can forward them with the names of the participants in the field to, in this case, to HART. I forward them to my business email system, so that way I make sure I've archived those. I don't want to be responsible for the fact that I might drop my phone into the toilet at some point, my phone dies, and I've now lost all this public business. So I make sure that all of my text messages are archived through email to my server at my office. So that's what my recommendation is. And I do it via screenshot. There's ways to do it other ways, but for me, screenshot is the best approach to make sure that those are kept in the system. Next slide. Social media accounts. The HART social media sites are subject to the public records laws as well. The contact is maintained in the social media format related to HART business, and including all communication posted by HART and received from citizens. All of that is a public record, and it is being archived. Use of official or personal accounts to conduct public business, regardless of having a disclaimer, without keeping those posts, would also violate the public records law. So you have to make sure that if you, as part of your public business, choose to comment or choose to do something else in the course of business, you cannot delete those posts. You have to archive copies of them. Even if you said something and you wish you hadn't and you want to delete your post, it doesn't take it out of being a public records law. Twitter accounts, Facebook accounts, people use the Instagram. I don't know what that is, but any of those accounts, those need to be used. Moderate social media accounts for all inappropriate comments. We do that. If you have your accounts that you're using as part of your public business, you should moderate them. You can hide comments as long as they're not deleted. But you have to be very cognizant if you're blocking people, because there's some First Amendment issues there. That's not really the subject of this discussion, but you just need to be cognizant that when you're using your own social media for the purposes of your public business, that your ability to block users is a little more limited. Next slide. Before I move on, does anybody have any questions? Like I said, I'm going a little fast, but I want you to stop me if there's any questions, or we can talk at the end.
I see no hands raised, so full speed ahead.
I'm just going to keep on going. All right, HART, this section relates to the HART members' roles and responsibilities. These are roles and responsibilities that are defined in the HART board policy, specifically 120.02. And I know you all know this, it's on the board, but like I said, some of this is a good refresher. Each board member who accepts appointment to the board is acknowledging that they have a fiduciary duty to HART, and they must obey all laws which are applicable. You're public officers, and that has a specific meaning in Florida law, and it is part of what we're talking about with requirements under the Government of Sunshine Law, Public Records Law, requirements under the Florida Constitution for public records and meetings. Next slide. And also ethical provisions of both the Florida Constitution and Florida Statutes, Chapter 112, which is the Code of Ethics. Some of you all that are part of other jurisdictions may have additional ethical obligations that are either in the Hillsborough County Code, the City of Tampa Code, Temple Terrace Code, or whatever other code, City of Plant City codes. There may be other options there, but for the purposes of this discussion, you're obligated to be in compliance with Chapter 112, which is the Code of Ethics. You all know that you need to, there's certain forms you have to fill out, that you have somebody ask you to fill out, that, like me, who's had to fill these forms out for years, always forget until the very last minute, and then I'm like, oh, I better get that in before somebody comes after me. So it's important that you get those forms in. Staff does a really good job making sure that those are done on time, and that's really important to get those in on time that talk about financial responsibility, talk about lobbying, and those other kinds of things. Next slide. In addition to your statutory requirements and Florida constitutional requirements, once you have been appointed to the HART board, each member also has a duty to comply with the statements and standards applicable to all HART employees as well, specifically professionalism and professional conduct. That's almost an employee ethics and conflicts of interest. That's very similar to what's in Florida statute, but much like the city and the county, there's some more specificity. And I think for HART it's really important too because federal money is involved. There's some other issues that you need to be cognizant of. Within those provisions, the discussion of avoiding the conflicts of interest, soliciting or accepting gifts, nepotism, and other policies. I do want to stop here to say if questions or issues come up, say specifically with soliciting or accepting gifts or conflicts of interest, because the conflicts of interest really are twofold. One are conflicts of interest is defined within the HART policies, but also statutory conflicts of interest when you're a voting member of a board. You are obligated under Florida statute to vote on every item that comes before you as a board member unless you have a statutory conflict of interest. There are limited exceptions in quasi-judicial proceedings. We don't really do those here, so I'm not going to get into that, but I'm happy to discuss that further. But unless you have an item that would go to your personal gain or loss, then you are obligated under Florida law to vote on those matters that are in front of you. If an issue comes up as it relates to what we call a voting conflict, there are specific forms that we need to fill out and send and put into the record. So if that issue comes up, please if I'm there or David Smith is attending the meeting or even ahead of time, just let one of us know ahead of time. We could advise you on whether or not a voting conflict exists. and how we need to proceed forward. Next slide. Before I go on to the public records request, is there any questions regarding roles and duties of board members, as well as any issues on voting conflicts or other ethical considerations?
No hands raised.
No hands raised. So I'm just going to keep on going.
Okay.
Here's the fun stuff, public records requests. We talked already about, we'll go on to the next slide. We talked already about what is a public record. When the rubber hits the road on your public records is when somebody makes a request. And these requests can come from anybody. And there's very specific ways in which requests are managed. It is important to note that any person, whether or not they're a citizen, not a citizen of Hillsborough County, whether they're media, non-media, whether or not they're Joe Schmo from Kansas or Canada, anybody has the right to make a request, and they don't have to direct that request to any specific person or employee. They need to just make that request. And it's important to know that that request can be either verbal or written. It can be made by any person, and we cannot make, and this is no governmental entity can make the request or fill anything out or write anything down. When that request comes in, it is transcribed into the requester's own words. Next slide. If a requester comes to the HART office to request a record, they need to follow the normal security protocol, which has been a very interesting issue during COVID when most public offices have not been open. But we've all managed to figure out a way throughout the state, this has been a big discussion throughout the state, to deal with public records requests. And so far, I think they've been handled relatively well without a lot of problems. The most important part is the sign-in process. And you cannot make somebody sign in and give their name if they want to make a public records request. You can't take their name if they want a public records request. In fact, when I was with the City of Tampa as the Tampa City Attorney, this became an issue, not on purpose. And I like to tell the story because this was simply good customer service. Somebody came in, I believe it was at the time the Construction Services Center, and they had implemented a way to manage people when they were coming in the door so that they could provide good customer service, not have people sitting around waiting for their appointment. So the protocol was to take somebody's name, which, again, that's just good customer service. Well, good customer service can go wrong if you've got somebody who's trying to do a gotcha during making a public records request. So somebody came in to make the public records request. They were asked to give their name so that they could be helped, and that person refused, and unfortunately also taped the interaction, and the person was asked again and said, hey, if you don't give me your name, I can't call on you. And the guy who was making the request said, absolutely not, and again was taping them, and then walked out. Well, unfortunately, that guy was one of the people who used to go around to governmental entities, of the Chandler brothers, if any of you have ever heard of them, and would make public records requests to people that they thought they could get you, and they did. And unfortunately, the City of Tampa litigation was filed, and this was, I don't know, I want to say like 7 years ago. We had to go ahead and settle the case because in the reality, you can't ask for the person's name. But in reality, that's the best way to get them the information. So people who really want the information would never go through that type of process. They would be very happy to give their name so that they're not just sitting there waiting. That being said, you cannot do that. And you have to be very cognizant that when you receive a request, you say, do you want to check back? Would you like us to contact you? If you would like us to contact you, you may provide us your contact information, or you can come back later. This is especially important if the records are not readily available, so that we can just find out, do you want to check back in? How do you want to get your information? It's sort of very circular, but that's the unfortunate only way you can do it and not be in violation of the public records law. The intent being that nobody should feel uncomfortable coming to the governmental entity and making a request for information that people might want to know why they're asking for it or what's the purpose behind it. And the sense was that made sure that people who wanted access to public records wouldn't be intimidated to get the public records. Now, fortunately, the public records law has changed where you can't just file those readily available lawsuits. There's more steps you need to go to. That being said, it is important to understand the protocol. Next slide. This next slide really just talks a little bit more about how you handle a very persistent requester and how you can handle dealing with them. And, you know, you have the right to seek assistance if you're sitting there and you're getting barraged with somebody, and the ways you can deal with it. And I'm sure those of you, especially the board members that are elected, you have interference that can be run by your aides or other issues who are very well attuned to this. But if you're a board member who just gets these directly made to you, and that is always a possibility, just try and do your peace and conflict resolution as best you can, and then reach out to either members of the HART staff or to general counsel, and we'll assist in getting that taken care of. But remember that you just have to be very cognizant to be sensitive to the idea that people who are probably being pretty agitated or might be also looking for a way to file a lawsuit. Next slide. If the requester is requesting the right to inspect or photograph public records, they have the right to photograph or inspect. They don't have to actually take a copy, and they should be doing that at the place where the records are normally kept, or as close to that location as the custodian of the records determines appropriate. That did become important during COVID as people were not allowed into buildings. If a requester wants to photograph the record, you can adopt rules relating to the photographing of the record and for supervision of the photographing process, but you can't stop people from taking pictures of records as opposed to seeking to have copies made. Next slide. This next slide just demonstrates a list of things you can't do when managing a public records request. You cannot make someone give their name, and I'll explain why that could be more problematic than you think. The person cannot be made to submit their request in writing, and that part's really important because sometimes it's really hard to understand what somebody wants specifically if they're just asking verbally in a general term. You can do the best you can to try and narrow them down by asking questions, but you can't make them do it in writing. You have to allow the materials to be photographed. You cannot refuse to provide the copy of the record in a specific format if that is how they are maintained. And you can't simply refuse this request. That being said, you are not, as a public entity, obligated to create a record. You're not obligated to put it in a format that is not a format you keep it in. You are simply obligated to turn over the records in the manner you have it, and you're simply obligated to be responsive. But you aren't. This isn't the ability to do interrogatories where questions are asked and questions are answered. This isn't trying to get someone to convert, documents that are maintained one way into another way. That part of it can become really important if you have a public records request, which is really trying to substitute in potential litigation for a discovery request, which those two are different. Even though you can get a public record given to you, even if there's litigation, you can't require it to be managed in a way that you can require it to be managed in litigation. Next slide. Just so everybody knows, there is a charge that we can statutorily require people to pay for copies. This is not as much of the norm nowadays because most things are stored electronically, and if you have it sent electronically, it's harder to charge. But sometimes the only way to get documents, especially old documents, is the old-fashioned way, through copying. Next slide. The other part of this, which becomes an interesting discussion point, is the special services charge. If there's a request that has been made that's pretty significant and that it's going to take a certain amount of time over and above like a readily available document, 15 to 30 minutes is usually what the norm is. You have the right to charge for the time it takes to pull together broad or voluminous requests. You can only charge the rate of the lowest qualified employee capable of completing the search, and you have the right to ask for the money up front, or at least a part of the money up front. A lot of different jurisdictions have a policy on the way they handle this. I have found in my experience that the second if you have someone who comes in for a public records request and they want every document that HART has ever received for the last 10 years, and you explain to them that's going to cost you $300,000 to pull that together, that tends to lead to, oh, by the way, you know, you can change your request, or you can specify in your request, and that might lower the cost, is the best way to get people to be more specific in the way they handle a public records request, because it's not free to pull together all the documents in the world. And this has been upheld. I have been in plenty of disagreements with press folks over this issue, and who have challenged the ability to charge the special services charge. And I have not ever had a problem making the case that it is completely appropriate to charge a special services charge if the requester is seeking a prolific and significant amount of documents. It is fair for you as a governmental entity, and that's where the frustration oftentimes does come in with public records requests. It is important to be able to be transparent, to get all the documents that you have, make those as easily and readily available to citizens. It's not just the point of the law. I think it's really important as governmental entities to do that. That being said, you can get to a point where the public records requests are overtaking your ability to do your job. And that, you know, is an ebb and flow and often a big point of contention with governmental entities, which is, I've got 10 public records requests. How am I supposed to do my day job when I'm spending all my time looking for documents? So that's always a big discussion point, a big challenge, but keep in mind that we do have that right, and that right does exist to be able to assist us in being able to afford the time it takes to look for public records. Next slide. Well, here's the fun part. This is where I get to spare people. The penalties for non-compliance with the public records law can range from a non-criminal infraction, removal from your position, a misdemeanor of a first degree, a felony, if it's really bad, a felony of the third degree. I've never seen anything get to that point. Typically, and those are personal penalties. Typically, you end up with a lawsuit against the governmental entity so that they have to pay for the attorney's fees for the person who did not get their public records. I have never seen much beyond that. That being said, when we go back and talk about the archiving of your text messages and emails, the making sure you don't delete from your phones, which is the biggest concern that local government lawyers have for their public clients. When you've got cell phones and you've got those items which are archived on your phone, to make sure that you keep those so that we don't get to a place where the inadvertent becomes purposeful. I've literally not seen purposeful in my career, But that doesn't mean that they couldn't exist or hasn't existed. It just means that nobody's told me that they've done it on purpose. So don't do it on purpose. Do the best you can. Archive everything, even if you think it's questionably not a public record, and make sure that you've saved everything. It's good to, in the public records world, it's good to be a little bit of a hoarder, is what I like to say. One final thing that I actually didn't put on the slides that I always want to remember to tell folks, certain types of messages are such as voicemails, are not necessarily public records. It used to be common belief that voice messages were transitory and therefore not public records, and I subscribe to that and I agree with that. So if you get a voicemail and it's a voicemail, I believe you have the right to not keep those. But we've moved into this world where two things are happening. One, if you get voicemails, as I get voicemails now on my cell phone, they're transcribed. I don't think that question's been answered as to whether or not those transcribings that happen in your cell phones are public records. The second thing that's happened with technology is if I get, for example, voicemails on my work phone, that voicemail isn't saved in my voicemail system, it's emailed to me. I would say that if that email contains public business in the voicemail, it very well may be a public record. That question hasn't really been answered that I've seen yet, but I think that I would argue that the email with the voicemail attached in that regard would be construed as a public record. So just those are two items that aren't in the slides, but I just want to put on everybody's radar screens. Next slide. The items to remember is think before you write something down. I always, before I text something or email something, I try not to text very much from a business perspective, from a public business perspective, because it scares me to put too much on a text message, not because I'm afraid of writing stuff down, but because I'm afraid of losing it. I try and use email as much as possible, but I also am very careful and cognizant about something I put into an email, and I always think to myself, what would that look like on a big screen in a courtroom? That is literally how I conduct my email. If I'm not uncomfortable with that being shown in a large screen, then I'm okay with it. If I would be uncomfortable with it being shown on a large screen, then I don't write it down. I do the following. I pick up the phone and have that conversation. I make sure that I can have that one-on-one conversation if I can make that happen. Now in the electronic world, it has become so much more efficient to email and to call. I mean, email and text and to call, but that's something that is a good rule of thumb. Something also to remember is a public records request can be made to anybody, including board members, including employees, and it doesn't have to be in writing. You can't ask for the requester's information. Let them supply it. Let them know it would be easier if they supplied it, but they don't have to. Don't create or alter an existing public records to fill a request. If it doesn't exist, it doesn't exist. It is absolutely a fair answer. It's as fair of an answer as anything else. We don't have any records which are responsive to your request. Even if you think you know what they're looking for, it is still better to answer that says, we don't have anything that is responsive to your request. And as I said, the penalties that I discussed, I try not to get people too upset about those because, it's rare, and if you just do the best you can and you don't do anything purposeful, you're fine. Okay, next slide. Before I move on into the Sunshine Law, open meeting law, do I have any questions?
No, everybody is just hanging in.
It's a lot of material for a Friday afternoon. It's always a lot of material. It's a lot of material for a Friday afternoon. Okay, but I don't think I'll be too much longer. Public meetings. As we're all aware, next slide, we are, as a public entity, subject to the Sunshine Law or Open Meeting Law. That's the Florida statutory provision that provides the public a right to access a governmental meeting and protects the public from closed-door decision-making. Chapter 286 Florida statute applies to all meetings held by boards or commissions of a state agency or authority. Doesn't matter if it's your general board meeting, your committee meetings, the litigation and claims committee meeting, any other committees that are formed in a governmental setting have to be open to the public. Even certain procurement meetings are open to the public. They are obligated, and the Florida statutes talks about all the meetings that need to be open. And these are not limited to officially called meetings. They can include, as we talked about, the workshop meetings and those types of discussions. And it also applies to written communications, and that's important to remember. The reply all in this setting is not your friend. It is not your friend. It's an accident, but if you're talking to if board members are on an email chain, reply all. Avoid it like the plague. Any discussions which take place outside the public meeting are referred to as occurring out of the sunshine. People like to call them shade meetings. I think that sounds dirty. I just like to call them closed-door sessions. Otherwise, they're not legal. The Sunshine Law is applicable. If it's applicable, you have to give reasonable notice of the meetings. Not super defined, but 2 to 4 business days is fair, unless there's either other things in rules or there's an emergency situation. Minutes must be kept of the meeting or other written documentation, but minutes is the standard. And the meetings must be open meetings to the public and accessible by the public, meaning you can't go to a restaurant and go behind closed doors and say that it's open to the public when it's really not completely open to the public. Next slide. What is the open meeting? It must be open to the public, where there's a right to comment before any decision is made. The public has a right to put in comments prior to a vote being taken on an action. That's very clear in statute. There's some limits, there's some thought processes and comments on when that has to take place, but before decisions are made, the public has to have a right to comment on that point on your agenda. This also includes any discussions between 2 or more board members about a matter upon which the board will take action. Board members can go to lunch, they can talk about their family, they can, and actually for your board it's really interesting, you can talk to other board members about non-HART matters, even if you're both in governmental entities, because that is not something that's coming before the HART board. I don't want to say that same thing for commissioners that are acting on items that come before the BOCC that also may become before the HART board. Same thing with City of Tampa members, but you've got to be cognizant of the fact that it's 2 or more board members about a matter which can come before the board, or the board is going to take action, and that can be in writing as well. Meetings are not restricted to direct communications. It can be between a third party, which is intended to relay the information about the official business, i.e. the conduit. You can't have a meeting with me and say, hey, would you mind telling the other board member this is how I'm going to vote? No, because that's a conduit. The whole point is they're not supposed to have those conversations outside the Sunshine Law or should have that level of information, and a conduit is no different than a direct conversation. These open meetings requirements, a committee or group that is delegated the authority to make a final decision. So if you as a board create, say, I want board member so-and-so to head up that discussion group, that they will make that final decision or a recommendation on a final decision to the full board, you may be creating a Sunshine Law board. So it's very important that if that's your intent that you do so. If that's not the intent and it's really just intended to be fact-finding, that we're not doing that. But just simply delegating that to one other member doesn't necessarily take you outside of the sunshine law requirements. Next slide. And actually, we've been talking a lot about when you don't have to have public comment, when you do have to have public comment, when do you have to have your quorum. Those are actual real questions in front of you. You don't require a public comment in certain sets of circumstances. If there's an imminent threat to public safety and welfare, an emergency type meeting, we've all become much more akin to those. Those may be dispensed if it would create an unreasonable delay. Items that are just ministerial, like approval of minutes, don't require public comment. When a matter is something that is discussed in a closed session, and there's very limited opportunities for closed sessions, litigation is probably the one that we deal with the most, but there's a few other opportunities, labor negotiations and those things where you are allowed to have a closed session, but and that does limit the public comment, but just because it's closed session doesn't mean you don't ultimately have to take something up in the public. It just either delays it or alternatively allows you to protect it for a period of time. If you're acting in a quasi-judicial capacity, which you do on occasion, but it's not very often, you don't have your public comment until you've actually opened for your hearing. You can place certain limits on public comments by adopting rules such as time frames allotted for individual comments. That is completely appropriate. Next slide. Reasonable notice and meeting location. As usual, the term reasonable just depends on who's looking at it. But reasonable notice has typically been 2 to 4 days. The meeting location needs to be someplace that members of the public or the press can attend if they would like to attend. And it can't be held in a place or a facility that is inaccessible to the public. Again, a lot of these things have really been, I don't want to say they've changed, but they've been stretched through the pandemic, creating such what's really been a fascinating time to deal with these issues. And right at the beginning of the pandemic, I felt like every day was like a law school exam for local government law on how do we hold these meetings and how do we move forward with the meetings. And I'll touch a little bit on that towards the end because this is the general rule, but it really has changed a lot since the pandemic. Next slide. Minutes must be recorded and typed and open to public inspection, and the typed minutes don't have to be verbatim, but can be a summary. You do a nice job here with your minutes. You take them up at the beginning of all your meetings, and that is part of the process that ensures that the minutes are placed in the official record. All votes must be taken publicly. You have to vote unless there's a conflict of interest, as we discussed previously, and the minutes must reflect the vote or the counting of the vote. Votes must be publicly taken is, important because, as I said, you can't use a conduit to get from point A to point B. We have to do this in the public, in the sunshine, so that the record is reflecting in one form or the other how the vote was taken, and that is one of the tenets of the open public meeting doctrine. Next slide. As I mentioned, there are exceptions to meetings being held outside of the public closed sessions, as I like to call them. Probably the one you talk about and see the most are when you're going through, you're in litigation, and it's actual pending litigation. Pre-litigation is not sufficient for this, where the attorneys come forward and are seeking to have a closed session for the purposes of discussing the actual litigation, and it's even more specifically to settlement authority or expensive litigation. This actually has been highly litigated and was an issue in Pinellas County in one of their smaller cities, where their small city did have a closed session. They went outside the parameters of settlement authority or of financial issues and actually discuss options for fixing the problem that was raised during the litigation, and that was deemed by Florida courts to be too far. It's very specific, and this is a very strictly construed provision. So I know when an attorney comes forward and asks you for a closed session, we have to just be very cognizant that we're doing so only for that which we have the authority to ask for, because courts take very seriously the idea that meetings need to be held in the public. Meetings relating to contract procurements can be held outside the sunshine. Those aren't typically in front of the board as a whole. Those are for your procurement processes and whoever is your procurement committees. Any portion of a meeting in which a security system plan is discussed, and meetings related to a risk management program. That's your litigation and claims committee, and they do operate as part of the risk management program that does allow that committee to operate a portion of its meeting outside the sunshine, so that they can discuss options moving forward. It doesn't even have to be pending litigation. It can be pre-litigation settlement. So that is, because it's part of your risk management program, that is something that we have the ability to do. Remember that the public must be given notice that a closed session will be held. They open in the public. The chair announces the closed session, the duration or the estimated duration or the time frame. And once the closed session concludes, you return to the open meeting. So you announce that the closed meeting has ended, and if an action is taken during that, and a vote is taken, not a consensus, but there's an actual action that is coming out of the public record, that has to happen in the open session. Just because it's a closed session doesn't mean what you say will end up in the public. The record must be made of the closed session that would be available to members of the public, say, for example, at the end of the procurement process or at the end of the litigation. So, you know, it sometimes can feel a little bit like you can just have a free-for-all and say what you want, but just keep in mind there's going to be some kind of record, whether it is a court reporter or somebody else taking a record of what you said, and it could become part of the public record. Next slide. This is the penalty section for the Sunshine Law. This is, I think, a much more significant level of potential penalties for those things that occur which are on purpose, not inadvertent. Inadvertent things happen. You know, you're with somebody somewhere. It's another member of your board. You run into them at lunch. Somebody else at the table brings something up that's in front of you. They start talking about it. You two look at each other and say, no, we can't talk about it. You know, that is life. We live in a community. We see each other. Things are going to happen. It is not purposeful. We're talking about members getting together outside the sunshine on purpose to get a decision point made so that they can go back to their meeting, and it's the done deal feeling. You don't want to be involved in the done deal, and the done deal is what has gotten people from around the state put in jail, ethics complaints, other issues that have happened. So, yes, this is a second-degree misdemeanor for knowingly violating the Sunshine Law, potential removal of the position as an ethics violation. Fines, reasonable attorney's fees can be entered against you. There's opportunities for declaratory injunctive relief, and that the action taken at a legal meeting is valid. Yes, those are absolutely concerns. There are also opportunities to cure Sunshine Law violations if for some reason they occur, especially if they're inadvertent. The item can go back to the board, a further discussion could be had, and we can seek to cure the Sunshine Law violation. You typically do see those kinds of issues come up when maybe you had a committee that got together and nobody really thought through the idea that the committee that was created as a Sunshine Law committee. although nobody believed it was a Sunshine Law Committee and they had been taking action. So, you think about it and you say, all right, well, let's go back and cure this problem. Let's go back and deal with the problem by having all of the information that was discussed inadvertently outside the Sunshine Law back in front of the public so that we can manage it publicly, allow people to have comment. And obviously, if somebody wants to make a different decision, they would have that right in that meeting. Next slide. Are there any additional questions, or I'm just going to go? We're getting real close to the end, so if I've had all of you nod off, I totally get it. I've had a lot of coffee today. That's how I've gotten past the Friday afternoons.
Still holding, still here.
That's why I'm trying to talk fast.
We're still here.
Very good. The virtual meetings into the future have upended all that I've just talked about. We knew what we were doing as governmental entities, as local government lawyers for a long time on how you handle this. You have your meetings in public. There was some opportunities to call in if you were sick or there was another issue, but as a general rule, we all went down to our respective board meeting spaces and held our meetings. And then COVID struck, and then the idea of how you hold a virtual meeting or a virtual hybrid meeting in the middle of a pandemic has really changed the way we hold meetings. And certainly the biggest part of this is not just the fact that from a technological perspective, we've all figured out how to hold these virtually. Maybe other people knew how to do this stuff before COVID. I had never done a Zoom meeting in my life before COVID. I didn't even know what that was. So the idea that we can hold these items virtually, and I think what I would say is that you could find ways to have members of the public have a level of involvement through this process is something that I don't think was contemplated under the Sunshine Law and under the idea that members of the public don't have to physically be present where that meeting is occurring to still have that same or even arguably better opportunity to participate in the meeting. So the whole premise, and even since I've written this portion of it, is continuing to evolve. There's now some statutory, legislative potential changes that are occurring. If you're going to be holding your public meetings or workshops virtually, you must ensure that you advertise your meeting, that it's clear that it's a virtual hybrid meeting in what you're advertising, meaning you can't just say, I'm going to hold this meeting at your regular space, but really you're not because you're holding it virtually. You have to make that clear to members of the public, but also that you're providing that opportunity for members of the public to either, one, have safe access to a physical office where the meeting could be heard, or providing the information to the public where they can access the meeting via some electronic media. So having that dual opportunity to either physically come someplace or alternatively electronic opportunity moving forward, even as we move past the pandemic, I think will allow the opportunity to continue forward with a certain level of hybrid meetings or virtual meetings moving forward. Now, this really doesn't apply when you're talking about quasi-judicial proceedings. There is a lot of concern by us local government lawyer wonks that not having people the ability to have a full public hearing in front of the governmental entity could create a problem down the line. We don't know that. We just are worried about it. And then the second part of that is really the idea that not everybody has the same ability to get on a computer, and having that opportunity for a person to physically attend a meeting, I think will continue to exist. Next slide. Regardless whether it's virtual or not, you've got to continue Zoom, Microsoft Teams, WebEx, the variety of ways we get there. You've got to provide the process for public comments, and it has to be available to the public before you take any action. That isn't going to change by our new opportunities for this platform. really important, I believe, that you enable your closed captioning if you're using any of these opportunities, or Facebook Live or YouTube, or however you do that, because the other component of this that we haven't really talked too much about is compliance with the ADA, making sure that those who are hearing impaired have opportunities to be involved in the meeting, to do other things to ensure you're ADA compliant. You still must take your minutes, make sure all the attendees announce their names prior to speaking. If you don't have somebody who can manage to know who is speaking, and that voice votes are done with a roll call vote to ensure that the record is clear. You know, and I think as we've developed into this, those have become a lot easier for folks to be able to manage. I remember, we used to have to read out how do we do these public hearings at the beginning, but now we don't really need to because we've all gotten used to them. Next slide. This talks a little bit about quasi-judicial proceedings. You don't really do too many of those, but just for your own information, if you are going to use the hybrid meetings, which has become somewhat as an available option, make sure the notices that are being mailed out, because typically those are mail notice, keep all of the virtual information within there, how you can get there, how you can participate, because that's taking evidence and testimony, and you have to ensure that occurs. You have to give an opportunity to ensure proper transcription of the hearing for appeal purposes. It's a great idea to use a court reporter. That's not always financially feasible, but at least being able to provide that opportunity that something can be transcribed for any phases that are afterwards. The quasi-judicial realm is really a little bit more of the Wild West on this, and, courts have turned more towards the use of electronic meetings. I think it'll be interesting to see in the future how far and how long that will go. I'm of the opinion that now that we've gone down this virtual path, it's going to become more of the norm, and I think we'll see more and more use of it. I know that there's some, and after I'm done, you'll hear from the lobbying team. I know from the state perspective, there are some statutory provisions that will allow the non-quorum virtual meetings during an emergency. I would say over time, we'll even get away from that, because I do feel that these meetings are more accessible to the public than everybody showing up at, 9 o'clock at County Center, where most people work or they don't have that opportunity, where now people have more opportunities to watch on their phone or participate without having an entire day spent. So I think when we come out of all this, one of the positive things, and this is just me giving you my opinion, is the use of the virtual meeting in a more specific way to allow more public involvement in governmental entities. Next slide. And with that, I will end, and I am available for any questions either this afternoon, or feel free to ask me any of these things at any time. When you give these general commentaries, you don't always think about the specifics, but when the specific comes up is when the question comes up. I appreciate everyone's time.
Thank you so much, Ms. Mandel, for putting together such a comprehensive presentation. As you know, us elected officials have to take 4 hours of classes in these matters every year and tick the box on our financial disclosure form saying that we've done so. I had asked before if we could count this, and I have to say that it is every bit as thorough and informative as any of the official classes. So, but it's always good, as I say, to have a refresher.
Well, thank you. Maybe I'll see what I can do to get this certified so that it will give you all the ability to not have to take them both.
Yes, that would be good. Commissioner Kemp, I see your hand raised. You're recognized.
Thank you. I'll just be fast. I just want to say that as long as we got on the conversation here, I do think in the future, and we've seen this at the commission as well, a greater opportunity for people to become involved virtually. I think it's a great benefit, especially with a county as large as Hillsborough County, for people to have to drive in, sit there and wait, and be able to participate. And I think there's thoughts about setting up, for instance, in our land use, we've had many more people being able to be involved. But if we were setting it up like the access in the remote locations where the issue is, or access in other places, so someone who couldn't get virtual access could either show up or do it virtually at some place that we make available. I think it's a real advantage, and in the future, I hope that we do incorporate that, because I do think it will help public engagement.
I totally agree. As somebody who has made that journey as a citizen for many, many years and look for parking and everything, I am hearing from a lot of people it's a lot easier for citizens to participate across the county virtually now that we're all learning how. Are there any other questions or discussion by board members? As Ms. Mandel says, you can reach out to her as things arise. So with that, I think the next item on our agenda is the federal update from Holland Knight. And you all are recognized. Good afternoon.
Good afternoon. Rich?
Good afternoon, and thank you all for having us this afternoon. I think we'll just introduce ourselves very briefly, if that's okay. My name is Rich Gold. I'm head of the public policy group at Holland & Knight. Have been working with you all at HART for many years, specializing in infrastructure funding, and appropriations, and grant work. Lisa, you want to intro
Good
yourself?
Afternoon. Lisa Barkovic. Also have been working with HART for close to 16 years now. And prior to that, I actually was a Hill staffer in the Florida delegation, and working closely on infrastructure issues for my former congressman and for you all. Jeff? You're on mute.
Jeff Booth, Booth Transit Consulting, a sub to Holland Knight in this contract, and I'm the transit guy. And I've been working in HART since 1995, so almost a long time. Let's just put it that way.
Great.
Carl?
So if we can, Lisa, we'll go to the slides, and I'll go ahead and kick off. So really our goal for this afternoon is to walk you through what's happened so far this year, where things are going, and what the opportunities are for HART, and obviously have discussion around that as we move forward. And I should just start out by saying this is going to be a year very similar to 2009, 2010, but perhaps in some ways even better from an infrastructure funding perspective. And the reason for that is not only do we have funding coming through the system for the American Rescue Plan, and we anticipate for an infrastructure bill, which we are all hopeful will finally happen, which will include the 5-year reauthorization of the transportation law in Washington. But also we have the traditional grant process, which we're working on with your staff, and Congress has decided to bring back community projects again, otherwise perhaps somewhat unaffectionately known as earmarks. And thus, we're not only dealing with sort of the normal grant process, but at the same time requesting funding both in the Transportation Appropriations Bill as well as the Transportation Authorization Bill for additional project spending. So when you combine, the possibility of the infrastructure bill with the appropriations process with the American Rescue Plan funding, there will be quite a lot of money flowing to transit and hopefully to HART specifically, if we execute as we hope to on the plan that we'll put together with you all today. So with that,
Next
let me.
slide. I was going to say, if we can.
Go ahead, Lisa.
There you go.
Okay, so first slide just gives you a sense of what is in the American Rescue Plan, which is coming in your direction as we speak. Obviously, the president signed it yesterday. We're expecting this money to pump through the system very, very quickly in order to help out with traditional formula funding and obviously particularly the loss of ridership that you all have been experiencing over the last year of the pandemic. Next slide. So this gives you kind of background on the bill. Obviously, the Senate passed its amended version of the House bill last week and sent it back to the House. The House was able to pass it this week and send it to the President. The President signed it last night, so a little bit of updated from what's on your slide here. So it has become law. In part, that was so the government could get the $1,400 checks out the door, or start getting them out the door today to taxpayers under a certain income level. And we expect most of the funds that you guys will be receiving to flow relatively quickly and easily without any kinks or impediments in the system. Next slide. So as I referenced, the return of earmarks, or as the new euphemism calls them, community projects, to transportation funding and funding more broadly, both in the appropriations and in the transportation authorization process. The House has announced its process, and all of the types of projects you will care about, from bus and bus facilities to any sort of road improvement projects, anything that would fit under HART's rubric will be eligible for earmarks. Earmarks themselves are expected to be more limited than when we last went through member-directed spending, which was in 2010. So each member is asked to only submit no more than 10 projects across all of the appropriations bills. So obviously funding will be, very competitive, and we're not going to be dealing with tens of thousands of projects. Also, funding is limited to 1% of the overall budget in any given year. So we're not expecting it to look like the bad old days, if you will, but certainly opportunities for public entities like HART. One of the other limitations just to be aware of is the private sector, under the House rules at least, cannot receive funding. We're still waiting for the Senate rules, and as soon as we have those, we don't expect them to differ significantly. We'll be able to start getting our requests in. Next slide, please. So as I mentioned, obviously we're starting through the process of transportation reauthorization, as well as working on a broader infrastructure bill that will be based off of last year's House-passed infrastructure bill, as well as President Biden's Build Back Better proposal. But the key to that will be the transportation reauthorization bill. And with regard to that, Congressman DeFazio, who's chairman of the House Transportation Committee, announced his approach to earmarks last week. So again, we will have member-directed spending or community projects in the transportation reauthorization bill. You can see here a slight difference than in the appropriations process, with a focus on projects that are in the STIP or the TIP as being prioritized, and making sure that your State Department of Transportation, local government, or your transit agency are supporting it. Obviously, you wouldn't submit a project that you didn't support, and that they are looking for projects that are pretty well developed, that are not going to have NEPA issues, etc. Next slide. So I'm going to hand off to Lisa here on HART's federal funding history and we can kind of move forward from there.
Right. So we thought it would be helpful when you're thinking about, and sorry for the euphemism here, the couple of different highways of going after federal funding this year, whether it's the annual appropriations bill, the FAST Act, or the normal grant process. Wanted to show where HART has been successful over the years, as well as looking at the type of dollar amount for the projects that HART has received funding for. Because obviously when you all are making those decisions and we're guiding you through what we're hearing from the Hill or from the administration, knowing what the average grant award or community project funding award will be could obviously help you make some decisions about how to best position your request. So over the past couple of years, it's obviously been a very it's been through the Bus and Bus Facilities Competitive Grant Program. And you can see there that HART has received, usually on average about $4.3 million for Bus and Bus Facilities Grant Award. And then if you look at FY 2010 at the bottom of your screen, this is the last year that Congress earmarked their spending bill. So you'll see HART just received $500,000 for a bus acquisition and $1.65 million for the light rail preliminary engineering. Next slide. And here at the bottom of the screen here, I'm going to point out, so the last time HART went through and received earmark funding through the Surface Transportation Reauthorization, which is the FAST Act now, the dollar amounts were significantly much higher. And so, you're going to be thinking about strategy from short-term perspective through the annual appropriations bill, where dollar amounts are going to be smaller. And FAST Act reauthorization, because it's a multi-year bill, it's a 5 to 6 year reauthorization bill, you're going to see dollar amounts much higher because it's spread out over several fiscal years. Next slide. Just again, kind of a quick snapshot. And where you see with these during these fiscal years, while the different line items here, it's because you had different members of Congress actually also make requests. So in terms of how we're approaching strategy this year, obviously your delegation, we know Congresswoman Castor is receiving requests. The one thing that is kind of a big question mark is whether Republicans will join Democrats in submitting community project funding requests. But obviously that could, open up to working with Congressman Cannon and Congressman Franklin on requests as well. I will say Senator Rubio has announced in the last week that he will not be asking for any community project funding requests if the Republicans make that decision. So, unfortunately, I think that we will not have the opportunities that we could have with the Senate, but obviously I think with the House delegation, we're all looking forward to seeing every member of the delegation make requests. Next slide. And then on top of the community project funding opportunities, we also have the regular grant programs that are open. So there is lots of work to be had and be done this spring. So we have HART is applying right now for the low to no emission vehicle grant program. Those applications are due April 12th. We are expecting the Build Grant program to open in either later this month or early April. They have to the end of April to open that program. And then we also know Bus and Bus Facilities will be opening this spring. So lots of opportunity, lots of grant writing, lots of appropriation forms and FAST Act reauthorization forms to be filled out. So talking to you now to kind of coordinate on strategy and identify what your top priorities are as an agency to communicate that with the Hill and the administration will be very important. And Jeff, I'll turn it over to you.
Thanks, Lisa. Next slide, please. Clearly aware of several priorities for the region in terms of capital investment grant projects, and obviously disappointment about the Supreme Court decision, but maintaining work on the streetcar project is important to continue to advance the project and be working on the things that are important to get a project, namely the governance agreement. We do expect the administration to request a sizable increase in funding for the Capital Investment Grants Program in FY22 and beyond, and also to fund projects that very close to an 80-20 match, which would stretch both FDOT and local dollars considerably compared to what the assumptions in the project was right now, which is 50-50. Obviously, the ongoing issue will be the source of monies to cover operations will be necessary before HART can get a grant for the project. But we do think the landscape around Capital Investment Grants Program will change at the federal level, and I think an early indication of that is what happened in the American Rescue Act, where Congress put $1.675 billion available for capital investment grant projects, with the idea of increasing the federal share and reducing the impact, reducing the state and local contributions, specifically as a way to try to address concerns at the state and local level about their financial situation. So I think that's an indication of where this administration will be coming when it submits its budget in the next week or two. With respect to the CSX corridor study, I would say there's also $25 million in the American Rescue Act. That's an opportunity that FTA is going to have to indicate how they plan to spend that money and whether they'll put that out as a candidate for proposal. And so that may be one candidate. The second would be to try to get an earmark for a feasibility study, as we did with the streetcar, as you showed, with Lisa showed the earmarks in the past. That's a potential candidate. And then Fowler Avenue BRT, given the cost of the project, it could be a candidate for build grant or eventually a small start project, but it could be a build grant. And there's several examples of BRT projects that have been built out of a build grant. And so I'd keep that option alive as something to think about as you're trying to determine your priorities. With that, let me turn it back over to Lisa.
Right. And I will say with our experience too, as Jeff mentioned, the small start projects, we have worked on several small start projects over the last couple of years. And one of the things that even the former administration took a stance on, and I believe that this would continue under the new administration, is when your project comes in under budget on a small start project, they are letting you keep that cost savings to a certain amount to reinvest within that corridor for projects that are related to the BRT route. And so we have had, Jeff and I both have had that experience, and this is something to kind of think about, where when you have those projects come in under budget and you still get a couple of $1 million that you can save and reinvest within that corridor or within that to help support BRT, FTA has made that decision that you can do that. And I think lots of agencies have benefited from that new policy that FTA has instituted. Any questions?
I see no hands raised. Board members, is there any questions about the presentation? Commissioner Kemp, you're recognized.
Thank you. Sorry, I didn't have my video on either. Very interesting. And in some ways, I don't know where to begin, but let me just ask a couple easy ones. I'm not sure if you had more to do here, but when you say Fowler Avenue BRT, I usually think of that as Florida Avenue, Florida with a bit of Fowler on it. Is that what you're referring to?
Yeah, that's what I'm referring to. So, yes. It's also been
okay, I just wanted to clarify.
It's also been referred as Nebraska Avenue, so I guess it just depends on the alignment you choose, but obviously that corridor.
Right. Okay, I just wanted to be sure because I wasn't totally sure. Yeah. And for a lot, and on the low and no emission vehicles, I don't know, because the deadline was or is April 12th coming up, and so I think I've heard something about this before, but and I guess this would be Adley with regards to maybe we'll even be talking about this Monday, but with regards to applying for electric buses to that, because I just imagine I know in the past there were all these agencies in Florida that applied for low and no emission. That was like 2017 or something. and we applied for CNG, and everybody else applied for electric, and everybody else got theirs, and we didn't. And I know in between we've gotten a CNG, but I'm thinking this is the place where we would start to be moving to electric bus, because I've heard that there is a real commitment as well in some way to electric over future CNG. Can you speak to that at all?
Well, I would say this, that I would be interested in Lisa's and Rich's response, but I do think this administration is trying to reduce our reliance on fossil fuels.
Yes, okay.
Which then suggests that I think they have a great openness to electric buses, and I think you're right, Commissioner, that if the decision of the agency is to move to electric buses, then part of what they'll want to see in a grant application is a real commitment to move in the direction of electric buses, meaning that as you begin to replace the vehicles in your fleet, you've got a board policy or board decision that says we're moving in that direction, so that they're not awarding you just electric buses without a clear board policy in that direction.
Oh, okay, thank you. That was good clarification. And then, of course, our bus and bus facility being way below substandard, but also at this time, because of electric bus technology and other changes, talking about even satellite facilities and things like that. I mean, and I saw that specifically in 2021, but I mean, I've been on the board for 4.5 years, and we've been down this path for 4.5 years, so I would see that as a good opportunity, as well as I'm just wondering, and this is probably more something, again, for us to discuss, and thank goodness, I'm so pleased to have Adley's expertise here, but even a good candidate for earmark for a feasibility study of CSX corridor, but I even wonder about something beyond that. And I know that a lot of preliminary work has already been done on the corridor, and I know that as well, Congresswoman Castor has had her eyes on that for a long time, and is very interested in us pursuing that in a vigorous way. And I know we don't have the sales tax money at this moment, but I do believe we can in the future. I also know that Sunrail, as you well know, Jeff, ended up, never having passed a sales tax, but having, and I know it won't probably be duplicated for here, but FDOT paying the full haul for their right-of-way, for their tracks, for their build-out, for everything, as well as 7 years of operating cost to date. But I would hope that we could do actually something more aggressive in terms of that, because I see that as a great opportunity.
Yeah, you're right about Sunrail, and I think that's been the FDOT policy, is to help support commuter rail projects and also provide 7 years of operation, with the assumption that the local governments, and this is obviously what's happening in Orange County with the Sunrail project, is they're having to come to the voters with the source of local monies to maintain operations. Now, the other issue with FTA is, since that was an FTA-funded project, the local governments have the obligation to come up with the operational dollars one way or the other, because they entered into an agreement with FTA to operate it for a defined period of time. So, they're under a lot of pressure to do something on that project, because FDOT will no longer support it after the 7 years. So it is incumbent to have a strategy about how to come up with the operating sources of operating monies, because once you sign the grant agreement with the FTA, you are committed to that project for the useful life of the project. So it's just something to think about as an agency. But yeah, I agree with you. I think I just used a feasibility study, Commissioner. I think we can define in the earmark, if the decision of the HART board is to move in that direction, then I think we define in the earmark exactly what the purposes of the money would be. And I think if, in terms of the $25 million in the American Rescue Act, they're probably going to put out a NOFO of some sort defining what type of project would be eligible for that planning dollar, for those planning dollars.
This is just all great news, and thanks for the clarifications.
Thank you. And Commissioner Overman, you're recognized.
Thank you. And thank you very much for the presentation. It's really helpful to kind of get an understanding of the bits and pieces we can put together to create a cohesive plan. One of the things that we've talked about I believe at the last meeting, was, really developing a strategic plan, especially in light of the decision and in preparation for another approach to generating a reliable revenue stream for being able to operate. I think now is a very good time to have a clear understanding of what our capital investments need to be. So, for example, we mentioned the fact that we do need an additional maintenance yard. It would seem that expanding that maintenance yard project to include the infrastructure necessary for electric vehicles would be a reasonable combination of effort to capitalize on both the idea of sustainable long-term electric bus, investment, not just for the buses, but for the infrastructure that's necessary to support it, to show that we're moving in that direction. And Commissioner Kemp and I were both in the transportation management area meeting this morning that last year put the CSX corridor study on the priority list. I anticipate that, based on some of the conversation we had this morning, that it will again end up on the region's priority list. And it could very well be well beyond the limited scope study we did before, which was largely just from, basically the university area down to downtown, which really doesn't work with a rail line and negotiating with CSX. I mean, they've got their lines, and being able to have a productive conversation would probably be more in line with a regional project among all the different, transit agencies in the region. That could very well serve us as a region quite well. I'm glad to see that the Florida Avenue, the BRT, the local BRT is making progress, and that makes sense. But for us to get where we need to go and to be able to convince taxpayers to come to the table for the overall operating funds, we do need a clear strategy on how to capitalize on the focus of the federal administration's goal in investing in transit, and that effort. And the last thing I want to do is be the last in line. So I would really love to see all of our sort of projects to see how we could fit them in the various different federal funding buckets that could be utilized, with the idea that we won't always be poor. We will always be poor if we always expect to be poor, but I have no desire to continue being poor. So to make the argument for this agency is to create that vision of where we want to go, but more importantly, to make sure we're taking advantage of these grants and advising the board members as to how we act as advocates with our state and federal legislators to help them understand why this is so economically important, not only to our area, but critical to the nature of the survival of transit and transportation in our community. So having those talking points, once we are clear on our strategy, on what we want to do, I think would be very helpful. I know that that's you guys' job, but it's also our job. And we do have, some relationships with our legislators. And so having them hear from the board of HART and those other related transit agencies that are on the same page for regional type of projects is something I think I've heard the administration looking for. They're looking for effective regional types of projects that make a significant impact. And we've just been sitting ready for decades, it seems like, trying to do one. So I'm pleased to see that we're really looking at how these work, and I would love to continue getting an update on how we've provided you with information to assist us in, getting these federal grants. So thank you.
You're very welcome. And one of the things I do want to point out is request for the annual appropriations bill is due into Congresswoman Castor's office March 31st. So in the next 2 weeks, we have to think about the short game appropriations request because it's just an annual appropriations bill. with smaller dollar amounts, and then we'll get the request into the Congresswoman's office, and then obviously we'll need you to continue to talk with her about your priorities so she prioritizes your needs along with the whole entire region, because she's limited to making just 10 requests. And so we want to make sure we're in her top 5 as a priority so we can ensure it to be funded. And obviously those types of conversations will happen throughout then the course of the whole entire year, so that she can continue to advocate for us when the bills make its way through the markup process and the hearing process and onto the appropriate floor. So
can I follow up on that concept? I mean, is it just absolutely impossible to get the Senate, which is a Republican majority, the Senate parties that represent this region to recognize the value of reinvesting in transit infrastructure or transportation infrastructure in this region?
So my guess is that Senator Rubio will support your competitive grant applications the way he normally has been for the past several years. But what he did last week is he co-sponsored a bill to ban the return of earmarks in the appropriations bills, which was a little bit unusual because he is a member of the Senate Appropriations Committee. So you typically do not have appropriators that say that they do not want to make these type of requests. Senator Scott has not announced a decision yet, so we could maybe possibly still rely on him. But my thinking is he'll probably say no too, but don't count Senator Scott out yet.
Okay.
But both senators will still support any of your build grant applications, your bus and bus facility grant applications. I think that because they have to be transparent about their requests, so anything that your member of Congress is going to make, they have to post to their website and say, I requested such and such a dollar amount. And I think that's sometimes where members of Congress don't feel easy to do, because if they get 20 requests from all of the different municipalities or eligible entities for requests, and they have to say, well, I only requested these 10, then they have some, hard decisions that they have to make with their constituents.
Understood.
Go ahead, Rich. Sorry. Okay, I guess I would say this, though, because this is a game the Senate has played forever and ever and ever on the earmarks, okay? Which is that there aren't any, quote, Senate earmarks, but when it comes to conference, and there are, in fact, earmarks coming over from the House, somehow those projects get supported in the final bill, and sometimes they even get increased in the final bill. But it's just the Senate at this point wants to not have to be out there publicly, but you may get private support, and they may, in the end, support the House earmarks, try to fight for them to be included in the bill, and they may actually add money to that earmark. So I think this still has to be played out exactly how they're going to handle this politically. So I would just take it for what it is right now, but recognizing that if there's momentum and somehow there isn't a political outcome to supporting earmarks for the House members, I think you'll see senators coming around, because the last thing they want to do is turn away money from the state of Florida at the end of the day, especially if you're Marco Rubio, who's on the Appropriations Committee.
Understood. Thank you.
Thank you. And Commissioner Kemp, you're recognized.
I appreciate that clarification, because I was thinking the same thing. It was actually a little bit confused by the conversation. So, that's what I would expect. But just to be clear, because you gave a deadline for 2 weeks from now, Lisa?
Yes.
And so the deadline for 2 weeks from now would be for something like up to what amount or what things would be good for that specific deadline and project. I just was a little unclear.
The guidance came out last night, and so what I would be recommending is finding a project in the $2 to $3 million range to make a request of the delegation. And so, and because the money needs to be spent within a year of receiving that award, so you're really, I think, looking at more of a capital purchase for the annual appropriations bill. So bus acquisition, I think, is probably the safest bet to do on this. And the Congresswoman has a deadline of, she made it March 31st because she then has to turn around and take time to sort through all of her requests and then submit to the subcommittees. The subcommittees have a deadline April 14th. So that's why, even though we're kind of a month out from when everything needs to be turned in, you know, in order to give everybody time in the process, we're all being kind of given 2 weeks here.
Great. That was good. I wanted to just understand that, and we could certainly use some buses.
And then I would think of the FAST Act as something much larger, and so the dollar amounts are going to be much larger on that, and obviously, yeah.
I just wanted to know the fast deadline. I didn't quite understand what the amount was and what the kinds of things, and that's what the other stuff. Thank you.
Mm-hmm. And that about wraps up our board discussion. Ms. LeGrand, do you have any closing remarks or advice for us today, this afternoon?
No, and I know I have on a little fur because I'm freezing in this house. So let me tell you. It's warm outside, but it's cold in my office. No, this was a great session, and I thought the dialogue was really good, so thanks to everyone for participating. And I took a lot of notes. I have my notebook here, so I have a lot of notes here. So it was good for me, too. I'm sure it probably was old hat for many of you, but for me, this was really helpful. So this is great. So
Thank you.
Thank you.
It's Jane. Sorry, I just wanted in the end with Lisa, I just wanted to jump in here. Mm-hmm. You know, we've been having discussions, as has everyone else, about the federal revenue sources, how that's going to be rolled out, what projects they're focusing on, all of those things. But I really think that it's important as we're moving these, you know, the transit projects like the streetcar CSX, the arterial BRT, that the voters that how serious we are about transit, especially when we're coming back with another referendum. So just sort of an overthought there. And then I also think it's critical. I just had lunch today with Bonnie, and we talked about this as well. I think it's critical that we're looking at projects, you know, for the city, the county, and HART, that we're all coming together as a united voice. I think there's so much strength in that. So I thank you guys for everything that you're doing, and, you know, much appreciated. And thanks for the refresher training there, Julia, and much appreciated with the conversation today. Thank you all.
Thank you. And if there's no other comments or questions or discussions,
I just have one thing I was going to ask.
Yes, Commissioner Overman.
Thank you. Before we ended up adjourning, so we have 3 committee meetings scheduled on Monday, but we don't have a board meeting before before April 1st or whatever the date is. But we don't have a board meeting before March 31st. So I'm curious, given when we do have a board meeting, and to give our board members as well as our legislative representatives some guidance, you know, how would we move forward on making recommendations on projects for the earmarks that are coming up for April 14th? Does anyone have some suggestions on how we plan on doing that? While we're still here?
Commissioner Kemp, you're recognized.
I think we heard that it's fairly de minimis, $2 to $3 million in the recommendation that it would probably be for electric buses. Seems to make a lot of sense. I just thought that was more or less a recommendation. And I know that certainly Congresswoman Castor, who has really been pushing electric buses and climate change, would want that kind of thing, and that fits with the budget of that. So it just makes sense to me that that would be the ask.
Yeah, I don't disagree with that, but we don't have a board meeting until April 5th to see if there were additional recommendations. So, other than what might come up at the committee meeting to allow those that attend those meetings to focus on those issues until then, but in order to give them guidance in terms of a board direction, we won't hit that deadline. Is that accurate?
If I may, I'm also thinking, of course, this is a workshop, so we can't give direction here, but that we do have, we have adopted the framework for legislative action, and that would certainly include clean energy, buses, and moving ahead with our long-range plans, even if it's just inch by inch. So, does anyone else have any input on that?
That answers my question. Thank you.
Okay. And if there's nothing else, I think bringing in this very meaty workshop with a lot of very good presentation and a lot of information, bringing this in under 2 hours, right at 2 hours, is a good accomplishment for a Friday on the eve of spring break. So thank you all. Have a good weekend. Stay safe. And the meeting is adjourned.
Thank you. You guys have a good weekend.